watu wanakuja kwa DDP.
Kama kwa pikipiki wacha tumwambie.
Hizo nimeulisa amefika wapi?
It starts normally with a young man. Young men.
We've received instructions from the Office of the Director of Public Prosecution, and to be specific, the prosecutors who are handling the Aror Kimwarer case, in a matter that they have been sued in their personal capacity, and the Office of the Director of Public Prosecution sued as well collectively, whereby the petitioners being Kituo cha Sheria, Katiba Institute, Africa, among other petitioners, have sought to have the prosecutorial powers of the prosecutors lifted and the kind of immunity they enjoy in their work lifted so that they can bear the responsibility of the dwindling fortunes in the matter that was dismissed under Section 210 of the Criminal Procedure Code. As such, it's uncharted times in that we're seeing the petitioners who are non-governmental organizations trying to take responsibility to the doorstep of the individual prosecutors. However, on this, we have our instructions, and our conviction is that they have gotten this wrong, because the kind of suit that they have filed in court is anticipatory in a way, in that they're afraid that those who are acquitted are likely to move to the court to seek damages for being maliciously prosecuted, and that if that happened, the NGOs ought to have come and approached courts when and after such had happened. So we are being confronted by a scenario in which the time of the court is being wasted in something that is being done in anticipation. Therefore, we will vehemently oppose the kind of moves that are being done by the NGOs, in that it's our fortified belief that that is not being done in a good faith, and that the same is being done for ulterior motives, to wit, fundraising.
Seth, thank you, members of for the state. Now, as an officer of the court, it has come to my knowledge there is a petition that has been filed before the High Court under the court vacation rules, seeking to be heard during this time of recess. What is fundamental and important is that the petition is predicated upon the events that happened a fortnight ago, particularly on the 14th day of December 2023, when Honorable Nyutu delivered a ruling which essentially set free 9 of the accused persons that had been charged with regards to some squandering or the loss of public resources in relation to the Aror and Kimwarer Dam. Well, members of the public will recall that the former CS Treasury, Honorable Henry Rotich, was one amongst the 9 accused persons. And one of the reasons that I gather that the court dismissed the charges against the accused person was that the court cited what is called dereliction of duty, that the office of the ODPP had failed to take reasonable steps to cause the successful prosecution of the accused persons. And for that reason, the current petition that has been filed by, amongst others, Katiba Institute, seeking that the Director of Public Prosecution in his person, Geoffrey Obiri, and Mr. Mureithi, both, all serving in the office of the ODPP, that one, they should be cited for having failed in their public duty. In my own personal capacity and view, I find this petition to be foolhardy. it is one petition that, number one, is speculative. It's speculative in a sense that cases of malicious prosecution are filed by people who are acquitted after a trial has been conducted. Now, there has not been, to my knowledge, there is no one suit that has been filed by the 9 accused persons seeking to be compensated by the government. So for that reason, this petition in itself is speculative. It is one that seeks to, in other words, also, put the cart before the horse. So for that reason, I find it with respect that it is speculative. And secondly, we have in the Constitution a doctrine called constitutional avoidance, so that the Constitutional Court is not available to hear and determine all manner of disputes. And if for one reason that there is a likelihood that a case will be filed as against the state, well, it is not enough for the petitioners, in this case, to have sued the ODPP, the officers of the Director of Public Prosecutions, in their own personal capacity. We have the ODPP Act that provides for some immunity, the immunity that is accorded to all public officers exercising delegated authority from the Office of the Director of Public Prosecutions. And for that reason, for the petitioners to go and seek orders, particularly as against the persons or the individuals acting in their capacities as the Office of the Director of Public Prosecutors or prosecutors from the Office of the ODPP, then I think that is just being mischievous. It is, in other words, threatening officers who will be acting from the Office of the Director of Public Prosecutions from doing their duty. So that is what I gather on my own capacity as an officer of the Honorable Court. And when the time is ripe, it is important that, well, we contextualize everything. That this one being a constitutional petition, the Constitution also accords some immunity to public officers while doing their duty under good faith. So it will be incumbent, and this is something that we are waiting to see, which is not revealed from the papers, the petition that has been filed before court. It is incumbent upon the petitioner to demonstrate to court what is there that should demonstrate the bad faith in Mr. Obiri's exercise of powers as an officer of the Office of the ODPP, in Mr. Mureithe's exercise of powers as an officer of the ODPP. So it is a wait and see so that we can see what they will do. But as far as I am concerned, it is speculative, it is vexatious, if you ask me, and it is one attempt of wasting the Honorable Court's time. Thank you.
A petition, a constitutional petition has been filed that is completely misplaced. It is an attempt in futility based on the advice that I'll give them so that they follow this. One, the Constitution in Article 2 provides that you cannot challenge the Kenyan Constitution before any court of law. That is the principle in Article 2. Article number 2 buttresses the position of the Director of Public Prosecution in Article 157. You cannot sue the DPP in any constitutional court, in any court, with a view on the question of his job description. The only grounds for removal or disciplinary action against the Director of Public Prosecution is in Article 158. Let them file a petition to the Public Service Commission for removal of the Director of Public Prosecution. So that petition collapses on that spot. Number two, on the state councils, the two state councils who they have sued, Article 232 of the Constitution provides that no public servant can be held liable, can be sued, can be prosecuted while discharging their mandate. And therefore, that being the primordial law of Article 232, that is why I said constitutionally, this petition is misplaced. The third issue that comes into is can they direct the Director of Public Prosecution on how to do his job? Article 157 says that the Director of Public Prosecution cannot be directed by anybody. Nobody can direct the DPP on how to work. And therefore, the facts of this matter are very clear. Waziri Rotich was charged by the then Deputy Director of Public Prosecution, Nuruddin Haji. Later, Nuruddin Haji moved from that office to be the Director General of NIS. A process to recruit a new DPP started, and I was part of the team that applied for that job. Within that duration, as we were battling with the current DPP and the others to get that position, there was no substantive Director of Public Prosecution to lead and to provide directions. The prosecutors came to court and requested the magistrate that we are waiting for the substantive Director of Public Prosecution to decide whether this matter should proceed or this matter should be withdrawn. The court, its lack of wisdom, because that was lack of wisdom, proceeded and demanded that the matter must proceed. The prosecutors, my good state counsels, told the court, give us time. It is our case. Let the Director of Public Prosecution be appointed. Let him be sworn in. Let him take office. Let him look at these files. Out of haste and out of wanting to appear that that is the only court that is in this country that will proceed when all other courts stopped and waited for the new Director of Public Prosecution to come into office. That court alone, out of the 475 magistrates' courts in this country, it insisted to proceed. And therefore, the prosecutors could not proceed because they get delegated authority from the Director of Public Prosecution. Out of it, the court went ahead. It recorded over 40 witnesses, but there were no directions on how to proceed. Therefore, that act raises very fundamental question on the competence of the court to handle matters, on the temperament of the court, and we shall be moving to JSC to file a complaint against the manner in which that court handled the matter. At stake, the mishandling of this matter by the court has resulted to Kenyans losing over 63 billion shillings. So the blame should go squarely to the manner the court handled the matter. Why was it that all other courts in the country waited for the direction of the new DPP to take office? But this court, what is so special to that court that any matter the Director of Public Prosecution has tried to withdraw under Article 157(8) of the Constitution, that court has refused and insisted the matter to proceed. So we shall be making an application to be enjoined as court officers. This is the NGOs, in summary, are on a fundraising mission. The NGOs want to appear that they are fighting the DPP's office for the purpose of fundraising. All of them have ganged up to show that they are really, really affected. They have no locus in this matter, and any form of a petition they are filing, they must go for a referendum to amend, to repeal, to change Article 157. So it is our position that this was a petition aimed to raise rent for January and February and 3rd. We know the economic situation in the country is so hard, and then you have ganged up to raise money from foreigners. We shall stand firm to defend the criminal justice system in this country, not to be infiltrated by those who are looking for funds so that they can pay salaries and rent for it. And we'll stand firm with the new Director of Public Prosecution and defend his office. And anybody aggrieved with it, that is his own share. We'll be making our formal application to be enjoined, and we will make sure that justice is done. For funds, they are misplaced. We'll be making an application to strike out that petition because it does not raise any issue. They should go and fundraise using other systems.